If you create a video using AI, do you own it? And what about a character that you create with artificial intelligence? Well, in this video, I am super excited to share a conversation with two lawyers who are experts in intellectual property, copyright, and the AI revolution. Julia Greenberg and Kristen Webb are lawyers with Fishman Stewart, and they were kind enough to hop on the Curious Refuge office hours to chat about intellectual property and the AI revolution. I hope you enjoyed this conversation. It was absolutely fascinating, and hopefully you find a lot of value from it. Enjoy.
Okay. Hi, everybody. Thanks for having us. I'm Julie Greenberg here with Kristen Webb. We're going to go over, we understand that you have these specific questions about AI, but living in the real world, we know that people think they want to ask questions about AI, but in order to answer them, we really have to give some copyright fundamentals so we can all speak the same language and so that you know what's going on. I'm going to do some of the copyright basics so that you have the predicate that you need to know so that we can then turn our attention specifically into the AI field. Just as an overview, intellectual property is the field that we work in, and it's the field that copyright and these issues relating to AI fall into. And just so everybody understands, we get a lot of flack for the word intellectual property, but really intellectual property is to distinguish what we're working with from other types of property. So it's real property, which is real estate. It's personal property, which are tangible things and jewelry and things like that. Intellectual property is not intended to be snooty, as people think, but it's really so that you understand it's from the creative realm. We think of intellectual property as having three traditional buckets: patents, trademarks, and copyrights. Patents are for inventions, scientific developments, novel, cool, engineering type things. Copyrights are for protection of creative works. And we also lump trademark into the three buckets of patent, trademark, copyright. Interesting, copyright and trademark are actually mentioned in the US Constitution, and the founding fathers gave Congress at that time the responsibility to govern those two realms. Trademarks came up separately and they are governed also by Congress, but it's not in the Constitution. So I think of copyright and patents, but copyrights in particular, they really have a place in our culture and they go back to the beginning of our country. Other things that are considered intellectual property, which come up a lot, are trade secrets, also name, image, likeness, and rights of privacy, things like that, which we're going to actually talk about specifically in the area of AI. But just to give you a basic sense of what we have to understand with respect to copyright basics. Copyright is the protection of a creative work, and it is born from the creation. So nobody has to do anything to get a copyright other than make the creative work. So if you put pen to paper, if a poet writes a little stanza on a napkin and creates this little poem, nothing else has to be done. That poet, that guy sitting at the bar with the napkin, owns the copyright in that poem. Nothing further has to be done. The ownership is sealed. If that owner wants to take that napkin, put it in their dresser drawer, and never use it, they have the right to do that. Nobody can make them use it. They cannot force them to use it. If the owner wants to use it publicly and they want to make sure everybody knows that they claim an ownership, they can use a C in a circle. You don't have to do anything to earn the right to make a C in a circle. As soon as you have a copyrighted work, meaning you created it, I encourage you to use a C in a circle. It does not indicate that you did anything formal. You own that copyright, and it's best to let other people know that you claimed copyright in it. It used to be a requirement. People sometimes get mixed up. It is no longer a requirement that you use the C in the circle, but it's recommended. It's at the very least, it's a deterrent from the bad guys who don't understand copyright law, and they may see it. You can also include a little disclaimer at the bottom of your work that says this work is protected by copyright, may not be reproduced or distributed without permission. That helps. Those things actually help in the real world. So when you have I just want to give a sense of there's the whole world, which has all these works which are in the public domain, and those works are free for everybody to use. Not so with those things that have copyright attached to them. It's kind of hard to know what things have copyright attached to them, but you should assume when you encounter a work of any type, whether it's a photo or a passage or something on the internet, you should assume somebody somewhere probably created that and owns it. How else did it get there? So you should proceed with caution, because if it is not in the public domain, it's in copyright. Now, copyrights only exist for a specific term. It's like a limited monopoly that is granted by the government. Typically, a copyright exists for the life of the author, the creator, plus 70 years. It does not, like I said, you don't have to go to the US Copyright Office to do anything. From your whole life until 70 years after your life, that is the typical copyright term. That term differs, however, depending on when the work is made, because we have had different copyright statutes over the years in the United States. And if the copyright statute in force, which has over the years has changed the term, if you are making your work at the time that the copyright statute gives a different term, you may have a different term. So caution, you can't easily tell what the term is. You kind of have to talk to a lawyer, or you have to understand copyright pretty well. You should assume, to be careful, that there is a copyright and it's probably still in force. There have been a lot of big party stakeholders like Disney, you're probably aware, who have lobbied very heavily to extend the term of copyright so that they can continue to enforce those monopolistic rights, almost farcically, because it's now considered no longer a limited term. It's been made so long that a lot of these copyrights basically are going to live forever, those Mickey Mouse copyrights and things like that. One of the takeaways we want everybody who leaves any talk that we give is to understand that just because you can see it, access it on your computer, view it on a website, on a Facebook post, whatever it is, that does not, accessibility does not mean it is available for you to copy. So even copying a paragraph out of a New York Times article, or even out of your friend's Facebook post, that is a copy. And any kind of copying without the author's permission is called copyright infringement. You don't have to know more than that. If it's copy, it's copyright infringement. It is proceed with caution. So if you do want to refer to something that appears to be in the public domain, it appears to be publicly accessible, you should not copy a paragraph and put it into your own work. You should provide a hyperlink so that the reader of your work can go to the original work. Never just copy and paste. And that goes, I can tell you, making the slides for this presentation, Kristen and I are very careful not to copy sentences from other people, because there's really no minimum requirement. We don't copy pictures unless we know that they're coming from a publicly previously vetted domain site. So proceed with caution when you encounter any third party's work. And that will be an important lesson in the field of AI, as Kristen's going to talk about in particular. Copyright protects a lot of weird stuff. It's obviously, it protects things like paintings and photographs and literature, but under the laws that have been made by Congress, weirdly, it also includes other things. It includes semiconductors, computer chips, software. There's some movement to get golf courses covered under copyright. So it's not intuitive. It's a statutory thing to know what is and what is not. What the conceptual understanding of copyright is that it protects the work. It doesn't protect the information that goes into the work. it excludes, right on the face of the statute, it excludes the underlying ideas, concepts, facts, typefaces. Simple things are not protectable. Recipes are not protectable. That comes up all the time. Recipes, the piece of paper that it's written on and the way you might set out your recipe, maybe that's protectable. But basically, the underlying concepts and how you make something and how you do it, that is just not protectable. That is why people use trade secrets to protect, like Coca-Cola, to protect their ingredients in Coke, because the actual recipe is not protectable by copyright. Phone books were, most of the people in this room probably never encountered those big phone books that we all did, but a phone book is just a alphabetical listing of people and their phone numbers. And while the people who compiled it tried to claim copyright in it, the court disagreed. Copyright is not in here from a phone book. Fashion, that's a question that comes up all the time. The United States, unlike many other countries, I don't know if I will say most, but the United States, interestingly, provides no protection to fashion design. Fashion design is considered utilitarian. Clothing styles are considered utilitarian, and copyright law in the US excludes anything functional or utilitarian. And that's one of the reasons that the fashion houses prefer to be located in Europe, but they do protect fashion. We exclude it here in the US. The word copyright, I think if you also come away with this understanding, the word copyright is together with the word copy and the word right. So it is the right to copy. We sometimes hear people misspeaking and saying it was copywritten. The word right is not part of this particular type of intellectual property. It's the right to copy. The exclusive rights that one owns when one creates a work is the right to copy, the right to reproduce, the right to prepare derivative works from the original work, which would be translations onto other languages, or making a book into a movie, a sequel, fan fiction. Those are generally all subject to copyright. You cannot make fan fiction. There have been lawsuits. I think it might have been a well-known one. J.K. Rowling really got upset with some of the fan fiction that was written by her stuff. You cannot use other people's characters and make an unauthorized sequel or derivative work on that in that way. To claim copyright in the work that you made, and let's talk about that napkin again, where somebody scratched a couple of stanzas on a napkin. What do you have to do to say that it has copyright inherent in it? Not much. Copyright requires very little creativity. It does have a small modicum of creativity requirement. So you can't just make a triangle and say, I have a copyright in this triangle. It does exclude things like common shapes and symbols, but it includes pretty much everything else. The modicum is very little. And here we have, you guys probably heard about the banana on the wall art that has a copyright in it. Somebody created. So how much creativity goes into it? Very little. We sometimes in our office test the limit. Somebody will come in with a design. We haven't encountered the Copyright Office saying that's not enough, but usually I think they're wrong. I mean, the modicum of creativity is very, very little. The other thing that is required to claim ownership in a work is that it must be original. And I want to just clarify what that word original is. Original does not mean novel. It's not like a patent that it has to be different from other things. It has to be original in the sense that it originates from you. The word original means not copied. You see the word origin as the root of original. That's the test of copyright infringement, that you didn't take it from another work, that you actually created it yourself. So, you know, go back to the Eiffel Tower picture. Two people can be standing at the base of the Eiffel Tower, or in this case, you know, that image. They're standing right next to each other. They each take a photo, and those photos come out looking identical. Those photos are not copied because they each originated with a respective photographer, but they look exactly alike. There is no requirement that it not look like something else as long as it was not copied. Now, that's to be distinguished from looking at the picture of the Eiffel Tower and taking a picture of it. That is a copy. Even taking somebody else's photo and making a drawing from it, that's a derivative work from somebody else's original work. So you can't start with somebody else's work, but what you make can look like somebody else's work. Who actually is the owner of the copyright? This is really important in AI, and it will come up. So it will come up again when Kristen talks, but it's very important to understand that it is the person that puts pen to paper. So it is the person who actually paints it. It is not the in the world of commissioned art, for example, the mall approaches an artist and says, we want to have a fountain or a sculpture in the middle of our thing, and we want it to have, you know, holding a giant plant and a this and a that, and they can give all the descriptions of what they want. That is not part of the ownership of the copyright. The artist who ends up making it is the owner of the work. So in the case of architects, for example, this has come up a lot because I do a lot of work in the field of architecture. The homeowner works with the architect. The architect has the drawing and the draft, all the ability to make the blueprint in front of them. And the homeowner is giving very detailed instructions. Push the bay window this way, make the stairs start here, lengthen the length of this hallway. There's very specific input from the homeowner. The homeowner owns nothing. The entire copyright is owned by the architect, even though they were being given all this information. Because remember, the underlying concepts are not the subject of copyright. So this brings us to what in the United States is extremely important, and it is that a person who creates the work is who owns the copyright. So this brings us to monkeys. I know Peter's going to love it, and you guys probably all have heard of it. If you haven't, you'll enjoy it. But this case brought out the importance of who owns the copyright. In this case, this was a freelance photographer who wanted to photograph the monkeys in this particular, I forget where they were, in some rainforest. He set up cameras all around. He couldn't himself get good enough pictures, so he set up cameras around that had remote shutter pressing operational things. So these cameras were set up, and monkeys were interested in the cameras, came up and through the remote took selfies that are hilarious and adorable, but they took them themselves with the remote shutter press. The owner, the guy's name is Slater, I forget his name, David Slater, I think. He found them published, I think he published them, but he found them copied and republished. I think in Wikipedia was the first problem. Wikipedia published them. He sued Wikipedia and said, you do not own those pictures. I own the copyright in those pictures. They went to court, and the court examined the facts on this and said, well, hold on a second. Who pressed the shutter? Turns out the monkey pressed the shutter in every single case. And so the resulting verdict of this was that this Mr. Slater unfortunately owned nothing. He did not own the copyright in those because the monkeys took the picture. And in US law, a human has to create the work. That's really important. And it's going to come back again when we talk about AI. But the monkey owns the picture, therefore there is no human creative part. And so even though all the setup and all that went into it by Mr. Slater was valuable, he doesn't own the copyright, and neither do monkeys because they are not human. So this is a really important foundational understanding in US copyright law, that the human has to create the work that comes out of it. That is not true, by the way, in all countries. They don't have this rule, but talking in the United States, that's really important. I also want to just go back to my commissioned work example when I'm talking about the homeowner and the architect, or I'm talking about the the city that commissions a mural to be put on their wall, and they hire an artist to create the work, and they pay handsomely to the artist. So they have an agreement, you make it, I'll pay you, $50,000, and then this work is now created. Who owns that work, that commissioned work? For many, many years, until 1989, everybody on both sides of that equation, everybody thought that whoever paid for it owned the resulting work. And so the person who hired the artist and the artist who got paid both walked away from that deal thinking that the city owned it or that the homeowner owned it because they paid for it. And in 1989, the Supreme Court issued a decision called the Center for Creative Nonviolence. It was that situation with a commissioned work. And the Supreme Court said, hold on a second. We're gonna change how everybody understands everything. We're flipping copyright law upside down. It's gonna be different from here on out. And they said, only if the person is an employee of the person who paid them, does the paying company own it? In other words, if you're an independent contractor and not a traditional employee, and they used in the case in the sense of having withholding taken out by the employer, parking in the parking lot, that wouldn't work anymore because we don't go to work anymore. But the Supreme Court said basically all artists own their own work unless they are a legitimate, fully employed employee of the person who is paying them. That means, and I'm sort of guessing that applies to many, many of the people in this room, working what you create in your working life, unless you're employed by that person who is asking you to do it, you own it. And you cannot be stripped of the ownership of that work without a written assignment. This is really important because this is one of the ways copyright laws in the United States were written to favor the artists. In part, it's because of this view that the artists are relatively unsophisticated, especially compared to employers and companies. And so artists have the right, they own the copyright, and they cannot be stripped of it unless they are given a written agreement that they sign. And so we can't have the commissioning party come in and say, no, we paid and they told me that I was going to own it. Doesn't matter what anybody says. They can't provide a written assignment that the artist actually agreed to assign it over. The artist continues to own it. And when we counsel clients, the business clients, we often advise them, you have to, you should work something out. If you want to own it, you're going to have to get the artist to agree to a written assignment has to be signed, and you have to have that at the end of the day. Otherwise, company or the paying party does not own it, and the artists own it for themselves. It's a really important rule to remember. Now, that doesn't apply to copyright licenses. Now, especially if you're in a situation where somebody asks you to create a work, it's presumed that they have the right to use and copy and distribute and do whatever they're going to do with that work because they paid you. So a license can be verbal and it can be implied. It just can't be an actual written assignment. So keep that in mind. It's really important as you go forward. I mentioned several times that the copyright exists by virtue of creating the work, and you don't have to do anything further to nail down that copyright. However, we have created in the United States an incentive plan to give you better rights as the artist if you do more than just shove it in your dresser drawer. If you want good rights to your copyright, we encourage you to take the time to submit a copyright submit the application and get a registration from the Copyright Office. The difference between an unregistered work where you did nothing and one where you submit it with a form to the Copyright Office is very, very huge from the artist's copyright owner's perspective. And that is, if you don't get a copyright registration, yeah, you have this copyright. You can tell everybody, I own the copyright. Not a whole lot you can do with that owned copyright, because if you find somebody has unauthorized within, unlawfully copied it and incorporated it into their work, first of all, you can't sue them until you go to court, but you can't even be heard in court until you obtain the copyright registration. So it's a ticket to court. You have to do it then. And second of all, you have to, without a registration, you would have to prove in your court case how much you've been damaged. And that's really, really hard in the world of art. Think about if somebody plays your song and didn't get permission, how much did you get damaged? It's very hard to prove. And because of the understanding that artworks are not easily quantified and the value for a copyright lawsuit is very murky, the system that has been set up by the United States Copyright Office is that you will get better damages. First of all, if you have a registration in place before the bad act, before somebody copies it, you're entitled to go to court and ask for statutory damages, meaning now you don't have to prove or quantify how much you've been harmed. You are entitled to statutory damages, but only if the registration was in place at the time. And just so you know, those statutory damages are quite hefty. Even if the person shows that they didn't know that it was copyright protected, you can get, what is I'm sorry, I'm looking up to $30,000 on statutory damages, even if they didn't know that they did it. If they did know that they did it, meaning let's say they encountered your work and it has a C and a circle in it, and they had no reason to doubt that, and they went ahead and copied it, you can get up to $150,000 per infringement. So imagine trying to prove $150,000 in damages without the registration. Probably never going to happen, but with the registration, you're hugely better off. And just on the subject of what can somebody who unlawfully copies, how do they get out of their problem? They don't. Copyright infringement is a strict liability offense. There are no defenses to a copyright claim. If you in fact copied a protected work, which we should remember is probably everything, you are liable, period. There is no defense. Even if you got a, signed in blood promise from the person who you copied from that they owned it, if it turns out that they also copied it and you're copying from a third party, you have a strict liability problem that you cannot get out of. And if they have a registration, you may be finding yourselves with a $150,000 problem. So you really, really want to be careful in terms of how you proceed on all these. Now I've laid out the basics of who owns it, strict liability problem, what are the cautionary things to look for. And now Kristen's going to talk about how this kind of works into the field of AI, which is what I think you're all here for with bated breath, wanting to know how we apply it. But now you kind of have the predicate understanding. Go ahead, Kristen.
Okay, so moving into how does AI fit into our existing legal regimes? The biggest issue that we're getting a lot of the questions about is copyright. We're seeing this explosion of AI tools across all different kinds of the creative fields. There's text, there's images, there's videos, there's music. I think Udio is one of the music platforms that's creating content. To give you a sense of the scope, which you may already know, but Udio was sued the other day. So it's been in the headlines, but they are cranking out 10 songs per second. I mean, the scope of how much AI generated work out there is just like my brain can't handle it. It's just so massive. So what does that mean for copyright? We're sort of seeing things shift into two categories. The first issue is what about these inputs? So the AI machines are being trained on these massive, massive, massive data sets. They're going out, they're slurping up the internet. Sometimes, probably even your own works are being ingested and used to train the AI. And there's a lot of money floating around, the billions of dollars with these AI engines. People are making tons of money, but there's no compensation so far being given to people whose works are being used to train these data sets. And they're not being asked permission. Some people just might not want their works being used for this purpose. So they're sort of losing an aspect of control that they should have under copyright. So that's the first issue, is the inputs. What do we do about these inputs? And the second issue is, what about the outputs? Is there any copyright? Is there any interest that you get in the outputs? Is there any liability for you taking those outputs and putting them online or using them in the wild? So that's sort of the two issues we're kind of going to cover a little bit. We'll spend probably more time on the output, since I think that's sort of the area of interest that we've got going on here. So to give you sort of a little bit more background with, copyright and emerging technologies, this really is not the first time that we have seen copyright law run head-on into new technology. Some people might remember VCRs, which is now an obsolete technology, but back in the day when everybody got a VCR and they started recording episodes that they were going to miss because they were out, out on the town or out at dinner, and they were recording these broadcast transmissions so they could rewatch them later, so they could store them, save them. They were making a copy of these. And there were lawsuits about that of, well, that's an unauthorized copy of a copyrighted work. In those cases, the court came out and said, yeah, okay, so they're using it to time shift something. So they said, okay, we're not really going to call that infringement. So it was very protectionist of that new technology, because we all wanted to be able to watch those episodes and not have spoilers the next day or try to catch it on a rerun later on. So we protected that new technology. We kind of saw the same thing go on in Google Books. If anybody remembers Google Books, Google took all the books in the world. They scanned them all and put them all on the internet. So now you don't have to go to the library. You don't have to go buy the book in a bookstore or borrow it from a friend. You can just go search it online and read the book for free on Google. And a lot of authors were saying, but what about, I didn't agree to that. I wanted people to buy my #1 bestseller. And the courts came out and said, yeah, okay, that's definitely copying. That's definitely public display and distribution of protected works, but it's not really infringement because we wanted that scanning technology. We wanted that public access. So again, we protected the technology. Sort of the aberrant case is maybe Napster, where it was peer-to-peer music file sharing, which is, public distribution. We're making a copy. I'm downloading it from somebody else and making a copy on my local device. In those cases, we said, okay, that's kind of infringing. So, you could see the music industry had a lot of weight in pushing their cause because they're losing revenues. So this isn't really the first time we've grappled with how does copyright handle new technologies. So we kind of see this same thing going on with AI of especially with these inputs of, okay, is that really infringement, or are we going to make some exceptions to help this? We don't want to hamper new technology if we can help it. And in order to make really good AI, you need these massive data sets. And it's just impracticable to go around and figure out who owns the copyrights in which work. They might be owned by multiple entities, multiple people, and getting permission from everybody is just not very feasible. So that's sort of one of the issues that we're really grappling with. There are over 20 lawsuits pending, and you can see that these are spread all over the different corners of copyright. You've got authors, musicians, news publishers, software coders, artists, photographers, everybody suing everybody. Most of these have to do with the inputs and using those works for the training data. Some of it has to do with the outputs. For example, the New York Times case, they're alleging that with enough prompts, ChatGPT will actually spit out a New York Times article verbatim. Beyond the paywall, you don't need the subscription anymore. You can just go and get the article from ChatGPT. It's also hallucinating and falsely saying that the New York Times wrote and published this piece that it actually never wrote and published. So there's some attribution issues there too. Now, All of these are being litigated. They're in the very, very early stages. So it's probably going to be quite a long time before we see any positive pronouncement of law, anything binding. This is all very murky gray area, very developing area of law. So we're going to get into, well, in the midst of this gray, what can you do about it? How do you protect yourself? So moving into the outputs, as Julie was saying with the monkey selfie case, generally our case law says you have to have a human author. The Copyright Office has come out with guidance on registration requirements for when you try to register AI-generated works or works where you used AI to help with that process. They have said you need to disclose that in your application so that we can pick it apart case by case and figure out where is the line between man and machine. They are still requiring humans participate in the traditional elements of authorship. Now, what does that mean? Nobody really knows. They haven't really given any further guidance other than saying nobody knows what are traditional elements of authorship to the Copyright Office. We still aren't clear. There's a lot of pressure for them to give us more detail on what that means. But so far, they haven't really given anything super helpful. So to turn and sort of look at some of the practical examples and try to find the contours of what are they interpreting their own words to mean. This is one of the first works that was submitted to the Copyright Office. This as an AI-generated work. This is a recent entrance to paradise. It was allegedly created autonomously by an AI called Creativity Machine, which is owned by a human person, Richard Thaler. So he submitted this to the Copyright Office and told the Copyright Office, okay, my AI created this all on its own. And it can't hold copyright. I get that part because that's a machine and machines can't own property, but I should get the copyrights because I own the machine. The Copyright Office said, no, there's no copyright at all to be owned by anybody because this was not created by a human. This was created by a machine. And you have to have human creativity, not machine creativity. So the Copyright Office is not the final arbiter of law, so you can actually take those refusals and go into court and ask a judge, hey, judge, do you agree with the Copyright Office or do you agree with me? So he went to court. The court said, yeah, the Copyright Office got this one right. You actually need a human with the capacity for intellectual, creative, artistic labor doing the creative part. And then a few months later, we saw Zarya of the Dawn. I don't know if anybody's familiar with this story. So this was a graphic novel, a post-apocalyptic kind of zombie sort of thing, created by Christina Cashinova. And so what she did, she used Midjourney to create these images. And then she wrote the text and the storyline all on her own, but she used Midjourney to make the visual part of the graphic novel. She did a little bit of tweaking after the fact on a few of the images, and she submitted it to the Copyright Office and said, I, Christina Cashinova, created this, and she got a registration for it. Then she went on social media and she bragged that she got the first registration for an AI-generated work. It went viral. The Copyright Office apparently found it on Twitter or X now, but it was then Twitter. They said, wait a minute, we're going to take that back. We're going to take another look at this and reopened the case. And after some letter writing, some back and forth and inquiry of, okay, what did you actually do? What were your prompts? And then also learning how Midjourney works, which is pretty interesting for the Copyright Office to have to go into take a class on how Midjourney works. They said, okay, those images, you might have used some prompts, but the images that were generated, the machine interpreted what those words meant in the text to image process. So it sort of randomly generated these images from your prompts that you then picked from. So we're going to give you the copyright back, but only for the text, only the thing you, the human author, actually wrote. Now those images, yes, okay, maybe you did a little bit of tweaking. You changed a little bit of the lip line, You maybe changed a little bit of the hairline and the shadowing. Those are de minimis. Those are not enough modicum of creativity to meet the threshold of human creativity. Now, I'm not sure if the Copyright Office was sitting in as an art critic here, so she could take that to court and say, actually, this is a really, really important creative choice. This is what makes or breaks the whole thing. You know, that's sort of a wait and see. She hasn't challenged it in court yet, so we'll have to see if that goes further. To go to the next one, we saw another one that came out in December of 2023. Now this one, in this work, the artist took this photo, actually clicked the shutter button and took a photo of the sunset. And he stuck that into an AI machine. He also plopped in an image of Van Gogh's Starry Night, and he told the machine, take my photograph and make it in the style of Starry Night. And then he put in how much weight how much transfer value he wanted it to put into that process. And then he submitted, the output to the Copyright Office. Copyright Office says, okay, tell me what you did. You took the photo and then you created this derivative work, but you only really put in a transfer value. That's not creative enough. You might have copyright in your underlying work, in the photograph, but the output, you didn't do anything for a color selection, for placement, for the swirling pattern. So it gave a little bit of guidance of, okay, what do you mean by traditional elements of human authorship? You are talking about color, you're talking about placement, you're talking about these swirling patterns and texturizing. So we're kind of getting a little bit more verbiage, a little bit more guidance, case by case, item by item of what do they mean by this? So this was ultimately denied. Again, we'll have to wait and see if that gets challenged in court, but for now, not registrable. There are some works that are going through the registration process and they are getting registered. But because the Copyright Office does not have like a database where you can go look up these works that are being registered, since your right to publish and public display is part of your rights as a copyright owner. The government can't take those and put them in their own database for anyone to see. So we can't really get a good idea of, okay, what are they allowing? That's still a bit of a black box. Now, copyright is very jurisdictional in nature, so there's some international treaties that kind of set a baseline, but there's a lot of wiggle room and nuance between countries as to how they enact those laws. So we're seeing different outcomes in different countries as everybody around the world is grappling with this all at the same time. We're seeing a little bit of disparity between the US and some other countries. For example, in China, the Beijing Internet Court has given copyright protection to this image here that was created using Stable Diffusion. They gave the rights to the artist that was using the platform, as opposed to the developer or the owner of the AI machine or the underlying work. They gave it to that artist that used the platform. In other cases, they've given copyright to the publisher. In one case, they said no copyright for an AI-generated report that was tables, graphs, which I think has more to do with you can't protect facts or information. So even if a human had done this all on their own, maybe there was no copyright to be had there. In other jurisdictions in the EU, you see a bit more harmonization over that originality standard, which is we have modicum of creativity. They have authors' own intellectual creation. We haven't seen much pronouncement of case law coming out of the EU just yet. There was recently, just a few weeks ago, one decision from, I think it was the Czech Municipal Court that said no copyright protection for an AI-generated image where the prompt was create this visual representation, two parties signing a business agreement, maybe in a conference room, like in Prague or something, and only show the hands. And so then they took the output, they put it on their website, somebody else took that image, put it on their own website, and the parties sued each other. The court says, no, there's no copyright there because there was no human creative aspect. There was no humans, intellectual creation. You just put in some prompts and the AI interpreted that, and that was that creative part. It was not human. But they left the door open. There was no bright line rule saying no protection at all for all AI generated images. They sort of left it open, saying, kind of hinting that if the prompts are original enough, if there's enough tweaking, if there's enough in there on the human end, maybe you can get some protection. But so far, that's really the only thing we've got coming out of the EU so far for the outputs. In other jurisdictions in the UK, things are a little bit more gray after Brexit as to what is applicable there, what is retained case law, what standards are going to apply. There is a portion of their Copyright Act that gives limited protection for works that are generated by a computer where there's no human author. So that really leaves the door open for those outputs being protected. They say that the rights are going to belong to the person by whom the arrangements necessary for the creation of the work were undertaken. Was that the developer? Is that the user? Who is that? Nobody knows yet. So that's an unsettled area. In the meantime, we're seeing AI platforms include contract language in their terms of service to try to provide some clarity until there's, clarifying legislation or until there is some case law on the subject. So we're seeing a little bit of proactive approach from the business end. Now, there's some very problematic things with some of these outputs, such as deepfakes. That's been a very big issue, especially with an election coming up. The US is heading into another election cycle. There's a lot of concern over misinformation and politicians being the targets of deepfakes. Around the Super Bowl time, we saw a high-profile case where there were sexually explicit photographs of Taylor Swift that went viral. Now, these were not copies of anything. These were generated content, brand new content. So they weren't replicated from an existing work. So copyright doesn't really do much here. She's got no way to say, hey, that's a copy of my work, since these are new works. But there might be some name, image, likeness issues because that's still her face. She might still have some rights there. So in the wake of this, Congress said, no, not Taylor Swift. That's America's darling. You can't touch Taylor Swift. So they started introducing legislation that would make it criminal and impose some civil liabilities for making deepfake content like this. Now, something like 97% of the sexually explicit deepfakes out there portray women. So this is really a women's rights issue. So it's nice to see maybe Congress taking this a little bit seriously and looking to address this. In the meantime, Taylor Swift's fans did not wait for an act of Congress. They took it on themselves to flood the internet with their own hashtag and sort of suppress that viral trend of these, unsavory images by posting positive images of Taylor Swift. But not everybody has the cult following that Taylor Swift does. So what does everybody else not Taylor Swift do here? So there are some name, image, likeness rights. These are sometimes called rights of publicity, rights of privacy. And like copyright law, which is a federal statute, meaning that it covers the whole of the US and all of the states, there's no existing federal law about name, image, likeness rights. So this is really just a patchwork of state statutes. Some states have statutes, some have some common law. It's very inconsistent, sometimes called a haystack in a hurricane because it's so undeveloped in some areas. There's more development in the creative centers like New York, where you have Broadway, in California, where you have Hollywood. So you've got a bit more development there, but everything in between the coasts is a bit murky. So we might be seeing more development of these areas as this becomes a bigger and bigger issue. Most of these statutes and case law kind of boil down to the same elements, though. Using someone else's name, their image, or their likeness, like their signature, without their consent and for some benefit, meaning you're making money off it. Sometimes even when you're not making money off it, but you're getting something like you're driving internet traffic to your website. Sometimes those can be actionable. So we've seen a couple pieces of legislation. So far, nothing has really come through yet. They're still sort of just sitting in Congress waiting for action. I think we might see a bit more movement as we get closer and closer to that election cycle, and we see more content, aimed at politicians. They might, in an act of self-preservation, start moving that legislation forward. When it comes to public figures, things like defamation get a little bit more tricky. When you've got, just a regular Joe Schmo on the street, defamation can be a little bit easier to prove. You just need to show that there was a statement that was made to a third party that was conveying an issue of fact, so not an opinion or speculation, that statement was false and that you suffered harm. But when it comes to public figures, because we want free speech, we want freedom of expression, you want to be able to criticize your government and your leaders, you need to show an additional element. There's a higher standard where you have to show actual malice, meaning that you knew the statement was false at the time you made it, or totally in disregard of whether or not it was true. This is going to maybe get a little bit trickier when we're deciding, well, who's a public figure now that anyone can go viral at any minute? Were you a public figure before? Does it matter that you became a public figure after so many likes, after so many views? So this is probably going to be another area where we see a lot of flux. Again, probably we don't have a lot of answers for you, but, just things for you to be aware of, because a lot of these things, there's no answers to be had just yet. Now, a lot of these name, image, likeness issues don't always capture voice, because it's your name or your face, your image, or a likeness that doesn't always capture a voice. And we're seeing more voice cloning coming out. For example, with Scarlett Johansson, recently we saw she had an issue with OpenAI when they held a live demonstration of their AI voice assistant. She thought it sounded a lot like her rendition of a similar feature in a movie. They said, no, that wasn't Scarlett Johansson. We didn't just take her voice from movies and train our AI on that. We actually hired somebody else who just sounds a lot like Scarlett Johansson. She may still have an action there. There are cases going back to 1988 about voice misappropriation and sound-alikes, where somebody has, before the advent of AI, somebody hired, Ford Motor Company had hired a Bette Midler sound-alike for an advertisement that they played, I think it was on the radio. She sued and said, hey, you can't imitate me. That's my voice, even though it was just a sound-alike, it wasn't her actual voice. And the California court said, okay, that's an actionable claim under California state law. So that's very limited to just one region. There was another case a few years later, kind of the same thing, where the singer Tom Waits, there was a sound-alike that was featured in a Doritos commercial. The court said, yes, that's voice misappropriation. But the elements are, you need to have a voice, it has to be distinctive, and it has to be widely known. So this was more of a celebrity cause of action. So as we're seeing more people become celebrities overnight, and YouTubers and influencers, maybe we'll start to see a little bit more of that picking up, and we'll see some other states developing in this area of law. For example, we're seeing legislation in Tennessee. Very recently, they passed the Elvis Act, which, government, they love their acronyms. So the purpose of this is to protect musicians from unauthorized use of their voice from artificial intelligence. So you're seeing voice clones like in Top Gun, Val Kilmer, they were able to reconstruct his voice. Randy Travis came out with a new song after his voice was decimated. And so he's, they were able to reconstruct that. We're seeing this AI used for a lot of really, really good purposes. We're also seeing voice misappropriation. There was another country singer, can't think of her name, but she discovered that somebody had actually taken her music that she had published, trained an AI, and then used it to record a whole new song that she never sang before, and was publishing that online. Her response was to come up with her own AI platform and to now license her voice so that people who want to write music and they want to make a demo and they want to use her voice, they can go on her platform, pay a subscription, pay a fee, and they can license her voice. So she's getting a little bit of economic revenue, recognizing she can't control the world and she might not have a cause of action, just any old place. That was her solution, was a market-based solution. So we might see other states kind of do the same thing and enact some legislation rather than wait for Washington to do it. In the meantime, we're seeing platforms baking things into their terms of service and terms of use. For example, ChatGPT, they're saying any potential rights in these outputs, that belongs to you, the user. That's all for you. And you know what else is for you? All the liability for using those outputs. That's on you. We're giving it to you as is. And not just that, if some third party comes along and says that those outputs are infringing their content and they try to sue the platform, you're going to indemnify the platform and you're going to pay their legal fees. So whether or not they're going to get blood out of turnips here, they're doing what they can to use contracts to shift that risk away from themselves and onto the user. We're also seeing some terms as far as when you take those outputs and you go to share them online, they have requirements for sharing, saying you need to disclose that you used AI to make this content, and they give you some model language that says, what to post with that content. We're also seeing some movement from Meta that had plans, and in some cases is taking everything that's on Facebook, everything that's on Instagram, and they're using that user-generated, anything you post, it's being used to train their AI. Now, they've halted plans in the EU, where the EU has much more stringent and robust consumer protection and data privacy laws that say you have to disclose that, you have to ask permission before you do that. We don't have those same laws in the US, so you can't, you don't even need to be informed about it. They don't have to tell you they're doing it. You don't get really a choice. So be aware when you're going to put your works out in the wild, you may be handing them over to be used to train, other AI machines. There might also be terms in there about commercial use. So if you're taking these outputs and you go to sell them to a client, there might be terms in there. So you're going to want to look for things like commercial use, non-commercial use, and you can use the search function in a lot of those terms and conditions to search through quickly, because it's pages and pages and pages of contracts that have certain restrictions on what you can and cannot resell as outputs. So to wrap up and do a few takeaways, do not assume anything on the internet is free to use. Do not assume that just saying, Getty images or giving attribution is somehow granting you a license. Don't use copy and paste where a hyperlink will work. Do use proper copyright notice. It'll help deter infringement. Do read the terms of service and use and sharing. That's where a lot of what we're seeing as far as any clarity in this is sort of coming from those areas. Do register your works promptly. When you go to register these works and you're going through that creative process, document your prompts, not just what prompts you're using, but really think about your creative process. Why are you choosing these prompts? If you're making tweaks after the fact, why is it so important to make these tweaks, and make that part of your creative process so that if you need to explain it to the Copyright Office or the court later on, you can show that those are your human creative modicum of creativity aspects. Now, you might not get full protection of the underlying AI, what the AI has interpreted your prompts to mean, but your creative aspects, you might be able to claw back a little bit more protection that way. We're telling people don't think so much in terms of bright lines, saying, okay, tell me where the line is so I don't cross it. That line is a moving target and nobody agrees where it is. So think more in terms of risk avoidance. use disclaimers, take a page out of the book of ChatGPT and use contract language to try to shift that risk away from you. You can try to shift it onto the client, say, disclose, hey, I used AI to make this output. I am giving it to you as is. Any liability for you using it, that is yours, not mine, and sort of shift that risk using contract language. Do stay informed of the developments in this area. It's fast moving-ish. I mean, this might be years and years before we see anything, real positive pronouncement of law that's binding, but it is still developing. And you do want to get involved in that legislative process. There's a lot of big money stakeholders out there that are wielding their power to move legislation, move the law in the direction to favor themselves. You can get involved too and try to wield the power that you have as a voter, as a participant in the process to move your laws in the right direction.
Kristen was just about to go into a more detailed Q&A session answering some of the most popular questions related to IP and AI, but this part of the conversation is only for Curious Refuge students. So if you are a student at Curious Refuge, you can just go to the office hours section to listen to this private Q&A session. I'd like to extend a huge thank you to Peter at Man of the World Media for setting up this conversation. And of course, a huge thank you to Julia and Kristen for hopping on and sharing their insights. Be sure to like and subscribe if you want more AI conversations, tutorials, and content directly here on YouTube. Thank you so much for watching. We'll see you in the next one.